Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we're going to take a trip to the Victorian Court of Appeal, and we're going to deal with a discussion about corporate oppression in the context of a sale of land. Now, what happened here is that a couple of families came together and decided they would run a venture together where they'd buy some land and then they would go on to sell that land. Now, in this instance, we have the piece of land that is bought in 2012 for $3 million and it is sold in 2015 for $11 million. And as you might imagine, there are a number of steps that take place between the purchase and the sale of that land. And what we have to deal with today is one sort of representative member of one family, if we think of that loosely, who we might refer to today as the appellant or the applicant or the defendant. They control about 60% of the interest in the arrangement. And then we have another person who we might refer to as the plaintiff or the respondent, and they control about 40% of the interest in the arrangement. And so we have a situation where the sale of land is set, right? Settlement's approaching, we found a purchaser, and this $11 million transaction is approaching. And what happens today is our appellant or our applicant or our defendant has to give some instructions and has to deal with the sale. Now, they give instructions to lawyers, they think about what sort of payments have to be made, and there are some sort of strange complexities in relation to these payments and some strange elements in relation to how these lawyers are being instructed and some strange elements in relation to how the documents come together. Now, one of the complexities in relation to instructing the lawyers is that our appellant instructs the lawyers to get to work on the documents, but doesn't give any instructions about the purchase price until the final moment. That purchase price is withheld, and it's withheld from the other parties in the venture as well, so it becomes a bit of a mystery. On settlement, there are a number of payments that are being made. There's about $8 million that is paid in the direction you and I might think of as fairly usual, paid towards legal fees, paid towards the costs of sale, paid to the vendor of the property, paid as part of real estate agents' commission, sort of payments that you and I might think of as reasonably straightforward when you're thinking about selling a piece of land. There are other payments that are less straightforward. One of them is the repayment of a mortgage that isn't really tangled with too heavily, but there are two other payments. One of them is made to a company that is controlled by the sibling of the appellant, and one of them is made to a company that is controlled by a person with no relation to the sale of land, a person who is a company that had been incorporated just a few days before settlement, and a person who has no apparent relationship with the nexus of this transaction. Right? It's just a strange payment to be made. And in interrogating the nature of these payments, what the primary judge finds at first instance is that these payments are essentially a pointless waste, to adopt the terminology. And so what's happened is the applicant has caused this transaction to go ahead where there are these various payments made, the $8 million of what we might call usual payments, the additional $3 million that includes these slightly strange payments for a higher quantum and in directions that you and I might find a little concerning, a little bit strange. And so, as you might imagine, and as you can tell by the name, the plaintiff, the respondent, brings oppression proceedings, and they come in the Supreme Court of Victoria. And in the Victorian Supreme Court, what they say is, hey, look, Section 232 of the Corporations Act works in our favour. This conduct in relation to the sale, and particularly these two very strange payments, that bends our way, and we ought to win. And the extreme short version is the primary judge says, yeah, that's right, and finds that the nature of the making of these payments and the sort of refusal to deliver up information when the plaintiff is saying, hey, can we have information about who we're paying and why are we paying them and where do we get these calculations from and that sort of thing. Can we have this information? A refusal to deliver up that information is also found to be relevantly oppressive, and there's declaratory relief that flows from that. Now, you'll recall that the name of the party or the role of the party who caused these payments to be made is the appellant or the applicant, and so we now find ourselves in the Victorian Court of Appeal, and the appellant is bringing an appeal of the primary judge's findings, and the nature of the appeal is actually quite interesting. There's no contest between the parties that the payments were appropriate. Everyone accepts this sort of pointless waste position that they delivered no benefit to the company, and they were pretty pointless when it comes to were they payments worth making, or were they payments for the benefit of the company or anything like that. No, they weren't. But what the heart of the appellant's appeal goes to is that their role was essentially a mere intermediary. They're sort of saying, hey, look, we weren't a director. We were just part of the mechanics of this transaction taking place. And now the outcome of this oppression proceedings is weighing heavily on us, and that's inappropriate, right? And so we appeal the orders made at first instance. Now, there are other elements of the appeal, such as delay. There were other elements of the appeal such that, in relation to the information, saying, look, the finding about us withholding information, look, that ought to be disturbed as well. The short point is, the Court of Appeal came to agree with the primary judge's findings and saw no means to disturb those findings, and they particularly tangled with this question that the appellant raised about, hey, look, I wasn't a director, I was a mere intermediary, I was just part of a mechanical process of sort of, ticks and crosses and whatever. I ought not to be held responsible for the way the transaction unfolded. I was, a mere vessel through which the funds flowed and the instructions to the lawyers flowed and that sort of thing. And so I ought not be held responsible. If that makes sense, it's a fairly fine argument, right? They are not saying, oh yes, the payments were appropriate. They are saying, appropriate or not, it was not my fault, for I was a mere intermediary, if that makes sense. And so, sadly for the appellant, happily for the respondent, they fail on that argument, and the court says, look, it's not a question of, a director's duty style question. That sort of misunderstands the nature of Section 232. The question in Section 232 is, has the conduct of the company been unfairly prejudicial? And here, in relation to those payments, the court saw no reason to disturb the primary judge's finding that yes was the answer in relation to the payments and in relation to the withholding of the information, and saw that there was no really relevant delay issue that ought to put the respondent, or the plaintiff at first instance, in a difficult decision. And so, I hope that discussion assisted you in relation to understanding a fairly knotty little piece of corporate oppression litigation, and I look forward to joining you again soon, hopefully sooner than the gap that's been between these videos we've recorded recently, for another coffee and another case note. Cheers.